Virginia Williams, and this is my terms of use presentation for Priceline. Question 1. Is it a valid contract? After reading the Priceline user agreement, I will have to say that it is not a valid contract. By definition, a contract is an agreement between private parties creating mutual obligation enforced by law, and that is the Cornell Law School definition. For a contract to be enforceable by law, it has to have 5 basic elements: mutual assent, which means both parties have to agree; offer and acceptance, there has to be an offer and it has to be accepted; capacity means the person's ability to adhere to the requirements; and legality, meaning it is legally binding. In this case, Priceline uses what is considered a browse wrap agreement, which claims to bind the user of a website merely by the visitor's use of the website. Although Priceline's term of use does state that by accessing the website, the user is adhering to the user agreement, I'm suggesting that if a user has not read the user agreement, how can they possibly agree to something they have not been notified of? In this case, the visitor can argue that they have not read the terms of use and they do not agree with them. In addition to this factor, the terms of use agreement is located at the very bottom of the homepage and can easily be overlooked. At no point in time does Priceline direct the visitor to the terms of use page to ensure that they are aware of what the website requires. A visitor could easily use the same argument that Patrick Neum used in the Neum versus Dick's Sporting Goods case. Patrick's attorney argued that browse wrapped agreements are enforced with reluctance, and only when a consumer has actual constructive knowledge of a website's term and conditions. The court later ruled in favor of Neum because the placement of the terms of use were not conscious enough to put consumers on inquiry notice of the terms. Question 2. Are visitors bound to it, or should they have to click I agree? Looking at the Priceline terms of use, visitors are not bound to the agreement because there is no location for the customers to indicate that they have read the terms and agreed to the terms. Browse wrap agreements are less enforceable by law in comparison to click wrap agreements. Now, in some cases, browse wrap agreements can be enforced by law when the site repeatedly brings attention to the terms while the visitor is using the site. Currently, the terms of use is located at the bottom of the page and not in plain sight. A user must scroll down to see the agreement, but not to use the Priceline service. Courts will likely find this agreement does not show meaningful assent on the part of the user. If you have a dispute with Priceline, can you sue them? Why or why not? Per Priceline's terms of use, it states that an individual could resolve the issue in arbitration or in small claims court, but the individual cannot pursue a class action lawsuit against Priceline. In addition to this, Priceline has outlined that before an individual takes the site to court, the individual has to give the company a chance to resolve the issue before taking legal action. Also, the individual must file the claim within 2 years from the date of the incident, and if the issue is not resolved within 60 days of the claim, then the individual can follow through in arbitration or small claims court. Technically, even though the terms of use states that it can only be handled in arbitration or small claims court, the individual could use the same argument as Kevin Nguyen in the case of Kevin Nguyen versus Barnes & Noble. In this particular case, Nguyen argued that he never read Barnes & Noble's terms of use, and therefore he was not compelled into arbitration. The Ninth Circuit Court agreed with Kevin and stated that Kevin was not provided with effective notice of Barnes & Noble's terms of use. The panel stated, in quotation, that validity of notice provided by a browse wrap agreement is based on whether the use of the website could put a reasonably prudent user on notice, where sufficiency of notice will depend on the content and design of the website. In this case, because Priceline terms of use are not easily recognizable, the visitor could object and refuse to resolve the issue in arbitration. Question 4. What changes would you recommend? I would suggest that Priceline includes a terms of use that provides a click wrap agreement located on the home page once the user enters the site. The click wrap agreement would request the visitor electronically signs the agreement and checks the box to click to ensure that they are aware of the Priceline's terms of use and that they agree with the terms. In addition to this, I would suggest emailing or notifying visitors electronically whenever changes have been made to the terms of use. This way, the company can ensure that it is effectively communicating any modifications with the site users.